members?
We administered those before the meeting, so that's checked.
Okay. And then, number 4 is the minutes from the April 10th, 2023 meeting. If there's, everyone got them and reviewed them, any questions, changes, omissions? Not seeing any, then I'll make a motion to approve the minutes.
Second by Rents.
I have a second. Do we need to do a roll call or just? Okay,
Yeah. Mr. Giller,
yes.
Mr. Rents.
Yes.
Ms. Steffen,
Yes.
Mr. Whitman,
Yes.
Mr. Lozick.
Yes.
Ms. Grafmiller,
Yes.
Ms. Frost.
Yes.
7 yeas, motion approved.
Item number 5 is reports and communications from officers of the board.
Yep, I don't think we'll have any of those.
So either. Then number 6 is other reports and communications.
Nothing else there.
Public comment is number 7.
Yeah, state your name if you could for the record.
I'm Paul Howard. And I live at 525 Red Bank Drive here in Sunbury. I want to start off by thanking the secretary for making the effort to notify me of the meeting tonight. I communicated with him months ago, and he or she remembered. Thank you. I've got 2 suggestions for changes in your rules and regulations, which you approved at the original meeting. The first suggestion is under section 4.4, conduct of the meeting, order of business, which is on page 10 of the rules and regulations. There are 10 items listed, and what should be covered in the meeting. I think that means to be on the agenda. And a visitor section and or public comment section is not listed. I think it should be listed in the rules. I'll note that on the agenda tonight, there is one listed. It should be in the rules too, in my opinion. The second item is in the same section, C, under addressing the meeting. I want to read part of your rules and regulations about addressing the meeting. I'm going to leave some words out, but you get the gist of it. Persons wishing to address the board must make advance written request for time to present oral communications to the board. This written request must be placed in the hands of the chairperson or any board member at least 2 hours before the meeting and must specify the subject matter, proposed communication, and amount of time requested. I did that months ago through the secretary. But that's a pretty onerous requirement, I believe, in order for the public to participate or communicate during the meeting. I think you should take the approach of many other public bodies in the areas, state of Sunbury being one, where you don't have to pre-notify, don't have to be in writing. You just show up, and during the right time, you're able to do what I'm doing. That makes a lot more sense. My suggestion is during your meeting tonight, you make those 2 changes to your rules. Add our visitors, public comment section in the list that's currently there, and change this section to not be so onerous. Thank you.
Thank you very much. Any comment on that on the board?
I understand the intent of item C, addressing the meeting, that the pre-notification and putting in writing comments is to prevent I guess a display that we would not care for. I'm not sure how to rewrite that or how to restate that.
Yeah, I mean, I think maybe one comment I would have is, a little different maybe than a zoning meeting or another open meeting. This can get very technical with questions that, you know, our attorney or accountant representative from us would be needed to help us with kind of answering that question. So I think from my perspective, having some information, I understand your point, and having some information prior to the meeting, I think would help us to be able to, whereas your comments today are easy to accept and take, because it's very easy to have this conversation. If it gets into a more technical matter, where we're starting to talk about the legalities of the document or something of that nature, I think we would, it needs some assistance from counsel or again, our, accounting representatives or bond counsel, whoever that might be on the topic. So I think from that perspective, I think it's helpful for, at least for me, it would be to have that information ahead of time. When we're having this conversation, it could be the most beneficial for both sides versus comment from the crowd and, or the audience. And we have to say, well, we'll take that into advisement. We have another meeting in a year and we'll get back to you. I think from our perspective, it'd be better to then have that good two-way communication right there. And as to, so that would be my point on that. And on the other, I think it's perfectly acceptable. They're open meetings. If that's something to add in, I don't have any problem whatsoever. They're open meetings, you know. I sent a lot of these. Very few times do I get a resident show up, but they're more than welcome to show up. And I think it's appropriate to answer the questions.
Could we maybe rather than require a pre-notification, say, you know, if you can pre-notify us, like if it's a technical matter or
Preferred, but not required.
preferred, yeah.
Yeah, I think that's, I mean, I changed however the board, I mean, obviously the board's going to vote one way or the other, but again, let's say we have someone sitting in front of us that wants us to answer a very detailed question about a bond issuance and why and what and how. We may not have that information sitting here. We may not even have the right counsel present at the meeting to deal with that particular question. So I think a pre-notice would be super helpful for us to do what we're trying to do and represent the authority in the community that way. But I think definitely the public comment section, I think clearly we have no problem. At least I don't think anyone else would have citizens show up or anybody who's interested in the process show up. So if we wanted to amend, so have our council amend that piece, we could make a motion if that's something the board wants to do, to amend that piece of it, but I would leave the comment, the notification piece in. Again, just my opinion.
I agree with your approach that if, you know, we didn't have the answer, it may be a year before we have our next meeting and that person's going to have to wait a year before we can have the proper representative here to assist us with the answer.
I think that's probably the one thing I can think in my mind. If it's again, a complicated bond question, the seven of us, again, we may not even have the right counsel necessarily sitting here at that meeting without us knowing that's coming. But if we knew it was coming, we could have the right counsel here to answer the questions, which would be more beneficial, I think, to the person asking the question than waiting a year.
I may. I'd like to point out the very last sentence in section 4.4C states all other addresses shall be at the discretion of the chairperson. I think that leaves it open to anyone who could come to and make a public comment would be able to do so under that sentence. And also, I am in favor of adding the public comment in the order of business. And I think with those two things in place, it should make it quite clear that we as a board are not hindering any resident or any person who would like to address the board. So I'd be in favor of making the adjustment to the order of business, but that's all.
So let me just ask this question. It's not on the agenda. Would it be best then if we kind of tee this up for the next meeting? The next time we're in front of them, we'll have a red line version of the rules. And at that point, we can make that adjustment. I recognize that may be a year from now, but that's the next time it would come into play anyway. So, and what I think I'm hearing folks say.
If we're just adding that one item, we can make a motion to amend 4.4, section 4.4A and add an 11th, 10th item, or however, wherever you want to put it, roll call, public comment section, we could say, add public comment section, probably in between six, add, takes 7 and bump it down to 8 and so forth and put it right in there. I think
Do you have, I was gonna say, Chris, your thoughts on that? Just
drop it in.
Yeah, I agree, but let's do it under other business, Trey.
Okay.
We'll do the resolution.
Okay, that's fine.
We'll do that. We'll add a new 7, right? Dana, social.
Yes.
Yeah, so we don't need them,
so we'll take that up under other business. It's, okay, thank you.
all right, good. Okay, any other public comment? Absolutely appreciate you commenting. Those are good feedback. Hopefully you understand both sides of what we're coming from that. And that just helps us all understand where we stand from this position. Okay, the next order of business is, comment we did that, introduction of new motions and resolutions. First one up is election of the chairperson and, board of trustees. So
open for nominations.
Randall Rents nominates Ann Frost. Second.
The second was from Ben. Okay. Any other nominations? All right. Do we need a motion to close the nominations, or can we just move straight to the vote? Okay, so let's, move to the vote on the motion for Ann Frost as the chair. All right, Mr. Rents. Mr. Whitman,
Yes.
Ms. Steffen,
Yes.
Mr. Lossick,
Yes.
Ms. Kraft Miller,
Yes.
Mr. Giller,
yes,
Ms. Frost.
Yes.
7 votes, motion approved. All right, Ms. Frost, you want to take it from here?
He's doing such a good job.
I was voted out.
No,
It was a coup. It was not a quiet coup. We knew it was coming, right? So there you have it. Don't want the developer on there. Could be trouble.
good, thank you.
All right, do I have any nominations for vice chair? I would like to nominate Mr. Rents as the vice chair, please. Second.
Right. Hearing no other nominations. Ms. Frost,
Yes.
Ms. Kraft Miller,
Yes.
Mr. Giller,
Yes,
Mr. Lossick,
Yes.
Mr. Rents,
Yes.
Ms. Steffen,
Yes.
Mr. Whitman.
Yes.
7 yeas, motion approved. All right.
Do you have any nominations for the secretary?
So this is an example where this does not need to be a member. And
Okay.
this has been legal counsel serving this role for this board. So
And that can remain?
I think that would be our strong recommendation.
Yes.
So and that would be Mr. Core, right?
So my
Tony
colleague, Tony Core, was nominated last year as secretary. He was here last year. For those of you who were on the board last year, you might remember. He is on vacation right now, so I'm stepping in momentarily as acting secretary. So I think it would be appropriate to re-nominate him.
Especially since he's on vacation and can't.
That's always how.
Can't say no, exactly.
I will make a motion to nominate Mr. Core.
I'll second.
Ms. Frost, Ms. Steffen, Mr. Whitman,
Yes.
Mr. Rents, Mr. Giller,
yes,
Ms. Kraft Miller,
Yes.
Mr. Lossick.
Yes.
7 yeas, motion approved.
Do we have any treasurer nominations?
So in this one, again, this can be an appointment for somebody who's not on the board. However, I mean, one of the reasons why we have, I think council has appointed Ms. Steffen to this board is to serve in that role. Ms. Steffen is the city's director of finance. So,
And can she remain in that?
yes, our strong recommendation would be.
I'll motion for Ms. Steffen.
I'll second.
All right, Mrs. Graffmiller,
Yes.
Mr. Whitman,
Yes.
Ms. Frost,
Yes.
Mr. Giller,
Yes.
Mr. Rossick,
Yes.
Mr. Rentz,
Yes.
Ms. Steffen. 7 yeses. We have a motion approved. All right.
All right, our next item is a resolution authorizing Sunbury New Community Authority to execute and deliver the first amendment to the Ravines at Meadow Ridge Declaration of Covenants, Restrictions, and Agreements for the authority.
So maybe, yeah, Chris, if you could just a little insight into what this motion is.
So the original declaration for the authority that was filed, needed to be modified, I think, due to a name change. Is that right, Trey? Due to a name change. So this amendment clarifies that name change and gets it into the chain of title for the properties out there. So any declarations need to be approved by this board, either accepting new property into the district or making a clarification like this, and that's what this one's for. So we reviewed it as legal counsel would recommend that it be approved.
So it's name change only.
So, shockingly enough, being the developer, I could explain it all to you. So what happened is when we brought Ravines of Meadow through, we brought it through as one property, zoned it as one property of Ravines of Meadow Ridge. We subsequently had 3 different developments. We'd always planned on building 3 different properties, 3 different distinct names. So therefore, we had to come back in and modify for Ravines of Meadow Ridge, Wilshire, and Legacy. So there's
Okay.
just same number of units, same property location, same everything else.
The 3 names.
Exact same.
Excuse me?
It's the exact same thing that happened to Sunbury Meadows. When the communities at Sunbury on that split on Route 3. It was all the Hershey property.
Yeah, I was gonna say, I'm not aware of that. I haven't been to those NCA board meetings, but yeah, there's no change in ownership, no change in the project, no change in location. Yeah. As has been indicated.
Approve.
Mhm.
Rents will motion to approve.
Second.
All right, Mr. Rentz,
Yes.
Ms. Graffmiller,
Yes.
Mr. Lossick,
Yes.
Mr. Giller,
Yes.
Ms. Frost,
Yes.
Ms. Steffen,
Yes.
Mr. Whitman.
Yes.
7 yeas, motion approved.
All right. Resolution 2024-2, accepting the declaration and levying the community development charge for the Eagle Creek subdivision within the new community district of the authority. Please explain.
So this is new property. It's a development that's being undertaken by Pulte Homes. Mr. Callahan is here to share some background on it. To formally add real property into the district, the property owner does need to file a declaration. They've prepared a draft. This resolution approves the form of that draft. The form of that draft is in your package. I have reviewed it. I've been in communication with Pulte Homes legal counsel. She's finalizing it, expects to get it filed in the next week or so. So again, we would recommend your approval. Before any motions, I don't know if Matt wanted to share with the board just a quick background on what's happening.
Sure.
Yeah.
Good evening, I'm Matt Callahan with Pulte Homes, joined with my colleague Nikki Martin. We both work in the land department of Pulte. So this community, which we just opened a few weeks ago, is over on 3 and Acadia Road in the city of Sunbury. And when we went through the zoning process, we agreed the development agreement with the city to join the community authority pursuant to that development agreement. So the community's been open a few weeks. We've had a handful of sales and off to a pretty good start. Ultimately, the community with 232 homes. Beyond that, not a whole lot to add, but I'd be happy to take any questions if you have any.
Is this on 3 and K north of 3637 or south?
South.
South.
Yeah,
Okay.
about halfway between 36, 37 and Cheshire Road.
Okay.
On the east side.
So on the east side, yeah, between 3 and K and 71.
Yeah.
This is adding real property into the district, is that correct?
Yes.
Question, sure.
I think we're good. Thanks, Matt.
Okay.
Thank you. And we have to do this based on the,
Recommendation from legal counsel.
but to add the real property in, that's part of the NCA.
So under the NCA statute, we need to accept the form of declaration. So the real property can be added into the district, and so it can ultimately be charged with a community development charge.
Anybody like to make a motion?
I'll make the motion.
I'll second.
All right, Mr. Lossick,
Yes.
Ms. Steffen,
Yes.
Mr. Whitman,
Yes.
Mr. Rents,
Yes.
Ms. Graff Miller,
Yes.
Mr. Giller,
Yes.
and Ms. Frost.
Yes.
7 yeas, motion approved.
All right, other business, we had previously tabled modifying our meeting rules. Would you like to make a motion on how they should be modified?
So it sounds like we're going to add a new number 7 and insert in that place, public comment. That's the recommendation. Okay.
Yeah, I can make a motion. I make a motion to modify section 4.4, conduct of meeting, small a, number 7, to add
Public comment?
public notification, excuse me, public comment, excuse me, public comment, as item number 7, and push item 7 to 8, 8 to 9, 9 to 10, to add 11. So we'll have 11 orders of business for a standard meeting.
I'll second that.
Mr. Giller,
Yes.
Ms. Steffen,
Yes.
Mr. Whitman,
Yes.
Ms. Frost,
Yes.
Ms. Graff Miller,
Yes.
Mr. Lossick,
Yes.
and Mr. Rents.
Yes.
7 yeas, motion approved.
All right, we need to schedule our next meeting.
And I'm not sure we do need to schedule the next meeting. Right, we don't have any pending business for the board.
Okay.
I think as a general rule, what we've done is we'll meet annually. I mean, at least that's kind of the schedule unless something else comes up. So I think at this point, we don't set necessarily the next meeting. If business does emerge between now and then that is time sensitive, we'll do the same type of thing, reach out to the board, identify a time and schedule the meeting accordingly, if that works.
It's likely, depending upon Mr. Giller's development and Pulte development, that we might actually be levying a charge starting next year.
Okay,
If that's the case, we'll need to conduct that business mid to late summer. So anticipate a meeting sometime in late July or in August. And if the developments have not progressed to the point where we need to levy a charge, then there's no deadline, but we would want to have a meeting, at least one meeting. So we'll be in a better position to make that determination late spring, early summer, and then we'll notify everybody.
thank you.
Also, one question and one comment. I didn't see board insurance. Just
Mhm.
do we not carry?
We do. I know, I do recall paying a bill for board insurance for the NCA
Yeah.
through Payne and Brown or the insurance company across.
Yeah, that's right.
Is that Payne and
Yeah.
Brown? Okay.
Mhm.
Yes.
That's right. Okay, so we've got that in place, but we can, if there's any kind of confirmation to send out to the board, maybe you could do that.
Yes, I can do that.
Just a safety measure. Yeah. And then the other thing that I would mention just really quickly is should have I believe Pulte will have houses and we'll have houses next year. The one change from last year to this year is the auditor isn't automatically assigning values any longer. So we'll have to set the charge, which is different from last year to this year. So again, pursuant to timing. So somebody will have to set the charge fee, the value and then the actual charge, which is different than we had talked about last time because he's changed his position on how he sets charges.
Okay.
So it's a just a little.
The developer is actually setting the charge rather than the auditor.
No, actually the board, us as a board are obligated to set the charge. And so more usually, I can't remember who's, so usually get it from, Argus does it for a couple boards that I'm on, and Bricker Graydon, they do it. So we'll just have to make sure that somebody's setting the charge for the individual houses, which is, it's just a change. So you don't give them the value anymore. You just give them a charge list, how much you're charging on that particular parcel.
Okay.
Good information.
Good enough. Thank you.
I sit on a lot of these.
Yeah, guess you do.
Any other items? Perfect. I make a motion to adjourn the meeting.
Second by Rex.
All right, Ms. Frost,
Yes.
Mr. Rentz,
Yes.
Ms. Steffen,
Yes.
Mr. Whitman,
Yes.
Mr. Killer,
Yes.
Ms. Graff Miller,
Yes.
and Mr. Lossick.
Yes.
7 yeas.